Thank you, Taylor. Hopefully everyone could hear me well. As Taylor stated, my name is Michael Fallings. I am a partner with Tully Rinckey, assigned to our Austin, Texas office. I focus my practice with federal labor employment matters. I also do private sector work. And I have litigated Equal Pay Act matters with federal government employees and with private sector employees. And as you know, the presentation today is about the Equal Pay Act and really focusing on how the Equal Pay Act applies within the federal government. The purpose of this presentation is to, as Taylor stated, give an overview of this Equal Pay Act. It is not meant to replace any case-specific facts for your matter you may have. If you are, have specific questions on your case, urge you to seek a representative to represent you. But this is really for general guidance on the Equal Pay Act. So with that said, we'll go ahead and start talking about what we're, for this presentation, what we're going to talk about. The topics, as you see on the screen, what we're going to talk about is really what is the Equal Pay Act? What does it mean? What does the equal pay for equal work mean? How to file an Equal Pay Act claim. We'll go through that. The burden of proof for an Equal Pay Act claim, which means how do you prove that your employer has violated the Equal Pay Act, and what relief? What are your remedies that employees can obtain for the Equal Pay Act? We'll talk about that today as well. So first, we'll go to the next slide on what is the Equal Pay Act. So the Equal Pay Act was enacted in 1963, excuse me, to protect individuals of all sexes. So specifically there, the Equal Pay Act is an act based on sex. The Equal Pay Act does not apply to other protected categories such as race or religion or disability. It's an act based on sex. And to bring claims under the Equal Pay Act, you have to allege that someone of a different sex was paid differently. You can bring claims based on race and religion or national origin based on pay, but those fall under a different statute. That's the Title VII of the Civil Rights Act. So the Equal Pay Act only applies to claims based on sex. But the purpose of the law was to protect and equalize pay amongst all sexes. And I mentioned earlier, it applies in the private sector, but it also applies in the federal government. It requires men and women to be paid the same for equal work. And we'll go through this, but it means that individuals that perform equal work must be paid equally. And there have been several cases over the years since it's been enacted, which we'll somewhat talk about today, that have really applied to the Equal Pay Act. But at its core, that is what the act is. It applies to sex, and it applies to equal pay for equal work. So for the next slide, equal pay for equal work. So what does this mean? What does equal pay mean? Well, equal pay means that the same pay. That's, we're pretty clear from what it says. The equal pay means you have the same pay. Now, equal work is where, there becomes disputes about what does equal work mean? Well, the case law has said that equal work does not have to mean you have performed the exact same work or perform the exact same job. It means substantially equal in the overall job content. And that really looks at the job duties, that are performed and how related they are. So again, it doesn't have to be exactly equal, but it must be substantially equal. Minor differences, will not render it unequal. And the courts have really broken this down even further to really a couple of different areas. The exertion, the mental and physical exertion that employees, exhibit in performing job. How equal are they? The level of skill it takes to, perform that job, and the training and experience. A court will look at that to see how. And again, we're talking about an evaluation of whether the two jobs that employees are performing are equal. They'll look at the skill level of the position. They'll look at the conditions in which the employee is working. Whether or not the one employee is working in the same type of conditions of another employee. These are all factors that a court will look at to determine whether or not two positions are of equal status. Are the job tasks similar enough? And in my field, I perform this type of work. It's legal work and labor employment work. If I'm trying to claim another attorney that performs tax law, is that equal enough? Obviously that's a different area of law, but then there's these other factors that a court may consider, such as the environment, the conditions, the mental or physical exertion, the skill levels. So even if I'm an attorney that practices labor and employment law, but if another attorney that this is just by way of example, works in tax law or criminal law, I can still make these arguments that we have the same mental or physical exertion, the same skill level, similar working conditions there. So that kind of gives you an example of why it's not exactly equal. The courts have not required that because often two jobs aren't exactly equal. But again, so long as they're substantially equal, a court will could find that the work is equal under the Equal Pay Act. And so moving on to the next slide here, how to file an Equal Pay Act claim. As we just talked about, to file an Equal Pay Act claim, an employee must show that an employee of a different sex, which perform a substantially equal work, but receiving an unequal wage. Now, for federal employees, and we'll talk about this as well, federal employees and really all employees do not have to actually go through the administrative exhaustion process. They could actually go right to court, and I'll talk about that here soon. But just to stay on this point really quick, is that these are the elements as far as filing the Equal Pay Act claim. You have the burden of proof. You have the burden of proof to show that you are performing equal work and another employee is being paid more, and then that other employee has to be of a different sex. That's your initial burden of proof. One key thing to point out is you don't have to prove intent. You don't have to prove that your employer was intentionally paying you less than another employee that was performing equal work that's the opposite sex. You just have to prove that there was a difference and that you're performing equal work. As I mentioned, if you make this claim, there's probably going to be a discussion, at least a dispute maybe, about whether the work was equal, but you don't have to prove that your employer was intentionally doing that. And under Title VII of the Civil Rights Act, which has the discrimination laws, you do have to prove intent. So these Equal Pay Act claims, or the burden of proof is a little bit lower than the Title VII claims because you do not have to prove that intent. So on the next slide, as I was kind of mentioning, as far as the procedure and filing federal Equal Pay Act claims. So like I said, employees can go right to court. You do not have to go through the EEOC, to file a claim with of the Equal Pay Act. You could go, you could go right to court to file those claims. Now, there are time frames to do so. You have to file within 2 years of the alleged unlawful compensation. Now, there was a recent law about 15 years ago now, where speaking about the 2-year time frame, And the law was the Lilly Ledbetter Act. It was in 2009, where they basically ruled that unequal pay is a continuous claim. So if you just discovered today that you have a coworker that's performing the same or substantially similar work is being paid more than you of an opposite sex, then you could file that claim, even if that pay had been going on for 5 years. So the time frame to file doesn't start from when the unequal pay began. It's a continuous action, and it really starts from when you found out. Even if you do find out and you didn't file for 2 years, if it's still ongoing, you're still within your time frame, and that's what the Lilly Ledbetter Act has stated. Each unequal paycheck is a start of a new action. And as we stated here on the slide, that actually is extended in case of a willful violation. Now, with willfulness, you do have to prove pretty much intent, or that willful engagement of the employer not paying the employee equally. Now, you can go through the EEOC process, and that's what we call the administrative exhaustion process, as some of you may know. Typically on Title VII claims raising race discrimination in the federal government and in the private sector, you must go to an EEO office before you go to court. Even though you don't have to on Equal Pay Act claims, you could do so. You could certainly have those claims investigated. Just keep in mind that these time limits for filing in court do still apply, even if you go through the EEO office. And that's why we put on there does not extend the time frame. For federal employees, it is important to note if you do go to court, you can file with a district court, your federal district court. However, if your claim for unequal pay is more than $10,000, there's a law called the Tucker Act that requires you to actually go to the Court of Federal Claims to raise those claims against the federal government. So if you claim that you've been unequally paid and that the amount you demand is more than $10,000 and you work for the federal government, you need to go to the Court of Federal Claims to make that claim. If it's under $10,000, you could stay with the district court. Another caveat here, and this kind of gets confusing, if you are claiming unequal pay based on sex, but you also have race discrimination claims or national origin claims, and you're trying to combine all of them, there is a chance you could stay in district court. But the correct procedure for federal employees over $10,000 is in the Court of Federal Claims. The Court of Federal Claims is still a court that has federal judges that will have a discovery process and could have a jury as well. But it is a different court than the district courts. The Court of Federal Claims does sit in Washington D.C. and the district court may sit in they have them all over the country, so that may be more local to you. But just note that as federal employees. Okay, on to our next slide here. So the burden of proof. Once an employee is able to establish that burden of proof of being paid unequally, but for substantially equal work, like I mentioned, the burden does shift to the employer. They do have the right to defend that claim. The employer has the burden of showing what they call an affirmative defense. To say, well, this unequal pay is due to, reasons that are not based on sex. And here are the 4 areas where the court has really laid out for employers to assert: a bona fide seniority system, a merit system, a system which measures earnings by quantity or quality of production, and a differential based on any other factor based on sex. One of the common examples, and that's really does apply across the board, is performance. You may have, a coworker that performs the exact same job as you, but is being paid less or being paid more because of their performance, and that is a justified reason. That makes sense for a lot of people. If a person is an outstanding performer, then then versus the person that is not an outstanding performer, then that person will receive, higher pay. A seniority system as well. If an employer has an established seniority system where, somebody may come in as the same position, I'll bring it back to my world, an attorney, but that there's another person there that may perform the exact same role, but it's been there for 5-10 years or longer. That could be in a seniority system where, that person is eligible for more pay based on this bona fide system that the employer has established. A merit system similar to what I just talked about, and even in the next one, the system of which measures earnings by quantity or quality is something as well, where it's based on merit, performance, or otherwise. That is a reason for additional pay. Now, where this gets, where case law has developed here is especially in the federal government, where you do have a GS system in place, is the courts have said, and the EOC has said, you can't necessarily rely just on this GS pay scale, so to speak, to differentiate employees. You cannot say, well, I'm paying this person more because they're just graded at a GS 13, for example, even though they perform the exact same duties as a GS 12 and have the exact same performance. This person's a GS 13. That's not going to fly. That GS 12 employee has the exact same duties or very similar duties. That GS 12 employee should get additional compensation. And that's where you've seen a lot of case law on that, because the employers haven't done that. The employers have not, given those employees those additional compensation. Now, and this is really true, when you have your GS 11 or 12 employee and you're asked to perform duties of a GS 13. Typically the government will try to do a temporary promotion, but if it's longer, then if it's an extensive period of time, the employer really should be, compensating the employee for those additional duties that the employee has performed. And that could lead to even other claims outside the Equal Pay Act. But overall, what the courts have said is employers cannot just rely upon a standard system to say, well, this person's ranked at a specific level, therefore they're going to be paid higher. There has to be some reasoning behind that. Ranking could be based on performance, but it has to be some reasoning behind it. It can't just be, well, that's their GS level. Going along with this, what you've seen a lot of case law in is negotiating for a higher salary when you're joining. And there's been case law on both sides on this, whether an employee that has negotiated a higher salary that has just joined, whether that's an Equal Pay Act violation, if there's another employee that's performing the exact same duties that's been there. And I've seen case law that says that negotiation is a bona fide reason, but I've also seen case law to say that it is not a bona fide reason. That an employer cannot just say, well, they asked for more, therefore we gave them more. That there's I don't think the court has settled on that. All I could say is if that is the situation you're in, you may want to consider, whether you have an Equal Pay Act claim there. I think, there's been, I think, dispute among the courts about whether negotiating, a higher salary would require an employer to match the salaries of the other individuals that are also working there. Now, employers maybe could defend that to say, well, this person has, more experience, or this person is, coming into a different position. But if it's for the same position, and there's really no other factors, it's just somebody asked for more money, I think that could put the employer in trouble. If there's another employee of an opposite sex that's paying or that's performing the exact same role. But again, the case law is not settled on that, from my knowledge. So on the next slide here, So for relief for federal employees, I mentioned the willful actions earlier. And if you were able to prove willfulness, that this was kind of intentional discrimination, you can get liquidated damages. And what that means is that under a normal Equal Pay Act claim, you could get the back pay you should be awarded, the pay you weren't awarded. And that's really the difference between what you were paid and what the comparator employee was paid. For liquidated damages, when you're proving this malicious conduct, that's basically doubled. When you're able to show it was malicious, that you weren't paid equally, then that could be doubled for those liquidated damages. Under the Equal Pay Act, you're not entitled to additional like pain and suffering or punitive damages or anything like that. But if you bring that claim with the Title VII claim, as I've kind of referenced, that's when that pain and suffering compensatory damages could be achieved. But for the Equal Pay Act, you're really obtaining the back pay, and if you're able to prove liquidated damages, you'll that even increased. You do get reimbursement of out-of-pocket costs such as attorney's fees. Those are really your damages for Equal Pay Act claims. And the Equal Pay Act, the back pay is limited to the back pay period of those 2 years, or it could even be extended to those 3 years as well. But that's what is achievable in Equal Pay Act claims. And so that was our overview of the Equal Pay Act. I know we did have some pre-submitted questions that I will bring up here.
If there are any additional questions, please submit them via the chat, please. Thank you.
So let's see. So one of the questions we received is equal pay relevant to job title, position title, GS level of duties and responsibilities? Absolutely. Again, going back to that substantially similar, analysis, your first burden is to prove that your job duties were substantially similar to your comparator employee. So that means that you're proving that you perform similar job duties, you have a similar position description. You have similar responsibilities. You have similar mental and physical exertion, like I referenced. Your working conditions are the same training experience. Those are the factors that a court will consider before even deciding whether or not the federal government had a bona fide reason. You have to prove that your job duties are substantially similar. So another question kind of references, well, how does this work with licensed independent professionals like physicians? Well, the federal government, the employees' physicians, and it's similar. I mean, physicians, there are physicians that work for the government. The Department of Veterans Affairs has physicians, Defense Health Agency has physicians, and different individuals that perform clinical work. You would have to show that you are equally paid to your comparator. So it does apply there as well. Another question asks for the relief. I did just talk about that and the relief that could be obtained. Let's see. Another question basically asks, I think, the application between a male and a female employee, co-workers, a violation of the Equal Pay Act. Can't really answer that specifically for a case, but yes, this does apply for differences in sex as well. And the other questions are not necessarily clear about what's being asked, other than what's already been discussed. Let's see. I don't think we've received any other questions, but I'll wait for a minute. Seems like the only question we received was very case specific, and it would be difficult to answer in this format. But like I did say at the beginning of our presentation, I'll repeat here: if you do feel you need an attorney on your legal matter, you should seek an attorney. We have our contact information here on the screen. Myself and other attorneys at our firm do work on Equal Pay Act claims on behalf of federal government employees. So with that said, it looks like I'm not getting any other questions. And so I think that will end today's presentation.
Thank you everyone for joining today's webinar, and thank you, Michael, for presenting. Today's presentation was recorded and a copy will be sent to all attendees early next week. I hope everyone has a good rest of their day, and thank you again.
Thank you.